Welcome to our webinar for today. I want to thank everybody for joining. I'll give you all just a couple minutes, and while we're waiting, do a quick introduction. I just wanted to thank everybody again for joining our DP Discover today, preparing HR and businesses to navigate immigration in a new administration. My name is Ryan Tagg. I'm the sales director here at Dominion Payroll. You may have seen me before for some previous webinars. But before I begin, I just wanted to give everyone a quick reminder that today's session will be recorded, and afterward you'll receive a copy of the recording following the presentation. If you have questions at any point during the webinar, please post them in the questions chat. I'll be monitoring that. We may answer during the broadcast or we may answer them at the end. Just be patient. We'll certainly get around to all questions, any and all questions that you put forward. Today we'll be joined by Garfinkel immigration law firm partners, William Hummel and Nam Douglas, to discuss the possible immigration policies Donald Trump may implement in his second term and provide us with some practice guidance to ensure continued compliance. I wanted to thank both of you for joining. I know this is like a confusing time as we go through the transition. Might be a little bit of fear out there, but here to kind of assuage any concerns and explain what's going on. And thank you all both so much for joining. I'll let you take it away from here.
Great. Thank you, Ryan, and thanks everyone for coming today. As stated, our goal is sort of just to give a broad overview of our thoughts, our best guess on where the next administration may be headed, sort of how you all with HR and businesses can prepare sort of for some things to come. And again, feel free to ask questions. We'll reply either during the conversation or at the end. We certainly want to save time for questions. Oops. Okay. Right, just a little bit about our office. So we're both partners. Nam and I are partners at Garfinkel Immigration. We're in our 28th year of existence. We're one of the largest firms in the Southeast dedicated to the practice of immigration. We do immigration law and only immigration law. And we represent businesses of all size, from Fortune 100 to 500 companies to small investor companies, and across the board in different industries. Won't spend much time on our bio. This is me. Just for reference, I do in particular have a partner at our office. I do in particular head our education specialty practice group. So within our office, I work with a lot of schools and universities, both public, private, charter schools, et cetera, across the board on visa options, as well as a number of companies in other industries as well. And Nam, I'll let you briefly introduce yourself.
Sure. Similar, I'm also a partner at the firm. I handle work with one of our largest companies. It's a global international companies, as well as some of our smaller mom and pop type of businesses who also have immigration needs. I've also done a lot of compliance work, as well as some family and humanitarian work. So can serve as a strategist for companies who may have multiple types of needs.
Just a disclaimer, as lawyers, we always have disclaimers. We're going to be giving general information, and again, some of this is our best guess on what to expect in the new administration. I think one immediate takeaway from today, for those of you wondering, is safe to say that President Trump, in his prior administration and his new administration, is going to be unpredictable. So I think that sort of, prepare for the unexpected. Again, we'll give you some tips as best we can, but I think that's more than anything, the unexpected is likely to happen in either regard. Our sort of agenda for today is just to go through what we saw during the first Trump administration, as we do think that's sort of a good guide as a base for what to expect to come back, what it meant both for employers and their employees on work visas, talk a little bit about worksite compliance in particular, because we do think that will be a focus of the next Trump administration is increasing worksite compliance. And then sort of end with some preparation tips now that you can do or pass along to your employees that are on visas. And then again, take questions and answers. So just to look back at the prior Trump administration, what he did during his first term in office, over the course of those 4 years, he issued over 400 executive actions that restricted immigration across the board, both permanent immigration, green cards, temporary visas, work visas, as well as the humanitarian-based immigration. We'll talk about asylum, temporary protected status, family-based immigration, DACA, the Dreamers, across the board. It really touched all facets of immigration. And we do expect some executive actions, again, restricting immigration in some form or another. Again, it touched across the board. There were restrictions on entry, both for humanitarian-based as well as those on work visas, limited immigration benefits, especially for those in certain immigration categories. He imposed additional requirements. That is, he, by executive order, added additional requirements and documentation to many visa types, changed adjudication protocol for the officers. There was an attempt to increase wages, in particular for those on the H-1B and the green cards, which we know the H-1B visa has been in the news recently. So that's something to think about. It employed extreme vetting, that is additional background checks across the board. And we saw this resulting in additional processing times for visas and green cards across the board. And then worksite compliance actions and enforcement against companies were significantly increased compared to past administrations. So again, that's what we saw before, and I think many of them are likely to come back in the new administration. We'll see what the priorities are as far as sort of order, but again, sort of is, I think, a good prediction of what we might see is what we saw before. Looking specifically at restricting entry and immigration, and again, what happened before / what we could see again. Travel bans, especially preventing entry from visa holders of certain disfavored countries, that is, countries that either have been designated state sponsors of terrorism, or another sort of political issue that came up that we saw as countries that do not accept their nationals for deportation, that is, those who have been ordered deported. There are certain countries that have historically refused to take people back. So that could be another sort of political reciprocity if they're not willing to accept their own citizens back, preventing any other future citizens from getting visas. Just rolling back the visa issuance process in general. During the Biden administration, there was an attempt to make visa issuance faster, more streamlined, more predictable, especially for those who were just renewing visas, who had already had work visas and just wanted to renew them. There was even a process where you could do it in the United States. There's a pilot program that allowed people to do that in the US, which you historically had not been able to do. So that may very well go away. USCIS, or the U.S. Immigration Service, has been very much over the last couple of years pushing an online filing that is moving to more a paperless or less paper system. And we think that process will likely be halted or maybe even rolled back, because again, that was seen as sort of immigrant friendly, customer service friendly. Premium processing, or the ability to pay for the government to expedite a case faster. Those opportunities, which have expanded under the Biden administration, he's expanded the number of visa types that are eligible. That could be rolled back or stopped temporarily, or the fees could go up as well. So we think there's ways that he could pause or affect premium processing. More in-person interviews for visas and green cards. Again, this was something during the Biden administration, especially post-COVID, in an attempt to clear the backlog. The Biden administration had ordered the Immigration Service and the U.S. Department of State to waive visa interviews and green card interviews as much as possible, absent any significant security concerns. So we do think that policy may go back to requiring everyone to have an in-person interview. Again, no matter the situation, which increases the processing times. Extreme vetting, again, that's additional background checks that would have to be cleared before USCIS, the Department of State, could issue a decision, leading to delayed visa issuance. So again, those are sort of, if he goes for the restricting immigration, particularly on the work visa side, those are things that we could see that ultimately delay people's transfer or just getting their visa on a trip home. Now, sort of more targeted would be actually limiting, not just delaying the immigration process, but really limiting options and benefits, the right to get work authorization or to remain in the U.S. So, for example, there was an attempt in the prior administration, Trump administration, to end temporary protected status, or called TPS, for certain countries, especially those from El Salvador, Honduras. Now there's Ukraine, Afghanistan, Venezuelan, Cubans. There was an attempt in the prior Trump administration to end TPS that did get caught in federal litigation and got held up until the end of his administration. But we think he could attempt to do that again, which again would be ending work authorization for almost 1 million people who historically have not required sponsorship. They've been able to work under their TPS, have an open work permit, so that could have a real impact on that population. Ending the DACA, the Dreamers program, again, that's another population that has never sort of required visa sponsorship, or work authorization or separate work authorization from a company. If the DACA population or their program was ended, that's over 500,000 people who could lose work authorization. Eliminating H-4 spouses, which is the spouse of the H-1B visa holder. It's possible that the Trump administration could try to target them, which again, that's another population that has had ability to get work authorization, open work authorization, who would historically not have needed visa sponsorship. I think not a more immediate, but sort of more consequential would be eliminating the STEM OPT. And OPT, for those that don't know, is the work authorization that international students get after they graduate. In particular, for those that graduate in the STEM, which is the science, technology, engineering, and math fields, have been able to get an open work permit for up to 3 years post-graduation. So it's a great opportunity for international students still to continue to work or to work in the US after they graduate, get work experience. Some of these students ultimately decide to go home or go back to school, but others end up needing visa sponsorship. But the STEM OPT, the ability to get that work authorization for 3 years, has been great because it's allowed students time before they need visa sponsorship, which is great for employers. They don't have to make that decision right away. Eliminating or rolling back STEM OPT, I think, could, from an employer's perspective, could force you to make a decision about visa sponsorship sooner, or again, the timing. So that could have sort of a real consequence for, especially for employers that are used to considering visa sponsorship. Bigger picture that would take a lot more effort, though, is rebalancing our legal immigration system from our current system, which there is both a family-based and an employment-based option, sort of two branches to get green cards, to fundamentally overhauling it to be a merit-based system or a points-based system, and which is sort of the model that Canada has historically used. That would require congressional approval to change the law. So again, wouldn't be something immediate, but certainly if rebalancing the system in general would sort of overhaul the way the immigration system has worked for years, and could put some people sort of in real jeopardy depending on where they are in their immigration process. Then lastly, on the humanitarian side, just limiting the number of refugees. The Trump administration, towards the end of his term, almost brought them down to zero. Biden administration has brought it back up to rather high numbers historically, but the Trump administration, again, in his last year, the refugee numbers were almost zero, practically speaking, due to visa bans. Sort of just getting into the additional requirements and adjudication protocol that we saw before or could see again. And this is actually the first one, going back to the no deference. This is some good news here, since we prepared these slides. So for context, when the Trump administration came into office several years ago, their policy was that even people renewing visas were not, that the renewal historically had been fairly straightforward. If you had gotten a visa once, renewing it, was fairly mechanical. Under the Trump administration, they got rid of that deference, they called it policy, and required USCIS to adjudicate every application anew and scrutinize it, in detail. Just recently, the Biden administration has put in the deference policy into regulation, which would be harder to overturn. Not impossible, but harder. So that is some good news, again, for people already on visas, that hopefully the deference policy, now that it's codified in regulation, will remain in place, or at least will be harder to remove. But if it was removed, going back to a no deference, would mean even people renewing their visas, it wouldn't be a guarantee that they could get it renewed, even if nothing has changed. Looking specifically at the H-1B, which is one of the more popular work visas that we see with employer sponsorship, looking at increasing the costs and requirements, whether that's documentation, additional documentation requirement. And I think more in particular for the H-1B is the talk of raising the wage level requirements. H-1Bs do have a wage requirement, to make sure that the H-1B visa holder is being paid the prevailing wage for that job type in the job site location. The Trump administration, towards the end of his first administration, tried to increase those wages pretty significantly in some cases. It ended up not going through. There wasn't enough time left in his administration before it could be implemented. So it never materialized. But if he did propose regulations to do that, again, for some wages, we could be looking at wage increases of 30, 40, 50%, in order to maintain their H-1B visa, which would be, in some cases, a significant jump in hardship for employers to keep them. Other adjudication protocol, looking at what we call public charge, just making sure that those getting the green card aren't going to become dependent on the U.S. government. This has always been a part of the law and the process, but under the prior administration for President Trump, they had to submit additional documentation to prove that, including credit reports, evidence of debt and liabilities, as evidence of assets or resources. So it was just, again, it wasn't a change in the law, it was just a change in the documentation. that was required that, doubled the amount of pages required for green card filings, which was a hardship on employees and employers, to get all that together. Was just significant documentation to get together. So we could see again the law wouldn't change, but just the documentation to meet this requirement could go up. And then lastly, I just pointed out that challenges for F1 international students, the limits to potential OPT, which is that work authorization post-graduation, ability to renew their visas. The Biden administration has tried to make it easier for students to go back home on their breaks, renew their visas without worrying about jeopardizing their studies. That was all based on policy, so that policy could be changed, almost overnight, which would make it harder for international students to get visas in the first place or to renew them if they want to go home. Now, delays and backlogs, again, sort of just what we can expect if these additional requirements are put into place. That means every case is going to take longer for immigration officers to review and adjudicate. Just for comparison, again, for the prior administration, the processing times increased almost 100%, even though the volume that USCIS only increased 4%. So it didn't match the increase in volume, but again, this all related to those additional documentation requirements, additional background checks that had to be run, and it made a real difference for people's lives because again, what used to was take 60 to 90 days became 5 to 6 months and similar. So if we see those additional background checks, we could see additional processing times. And USCIS, unfortunately, between COVID and other factors, has never really recovered pre-COVID. So processing times, even under the Biden administration, did not go back to their historical averages. They've remained rather high. So, to go up even further would be a hardship, I think, across the board. We can talk about, family-based unbundling, that is individuals here on work visas that have families on dependent visas. Unbundling that is not processing them together, which can lead to frustration and hardship for family members, especially spouse and children. If they're not able to get their visa approved at the same timeline, that could lead to problems with work authorization, travel authorization, renewing driver's licenses, etc. Rolling back regulations related to those spouses' ability to get simple work authorization. President Biden had made the certain spouses have always been able to work in the U.S., but President Biden made their ability to prove their work authorization more streamlined, simplified, so that they didn't have to apply for extra benefits. That could change back to the old regulations, which required them to apply for special work permit to get the work authorization needed for I-9 forms. So again, that can just lead to delays and backlogs, not only for employees, for those that have work visas, but for their family members as well. Now, to talk about some hope, some possible good news for immigration, especially based on what's been in the news over the last couple of weeks. For those of you that have been paying attention, there is definitely a tension that we see in the Trump administration between different of his advisors, especially those on the Elon Musk side, for example, that have been talking and promoting high-skilled immigration. There is some hope that on the higher-skilled immigration, there could be some positive changes. That includes addressing the H-1B cap or the lottery and the high demand for that visa. There's been some push to increase that quota, so that we aren't giving visas away based on a lottery basis, that it's more merit-based, which could have, some positive implications there. Addressing the green card backlog, the green card backlog for everybody has gotten worse over the last 2 years. Again, green card processing delays due to quotas, et cetera, have gone from 2 to 3 years to 4+ years. And then from certain countries, if you're from India or China, your green card quota is even more delayed. So there's been speculation again about maybe changes to address that green card backlog, make green card processing time, especially from maybe if you're from India and China, significantly less. That would require congressional approval. So again, not something done immediately. And then lastly, sort of the biggest potential, which we've heard in the news, is there's been talk of giving green cards to those that graduate with advanced degrees, a green card with your diploma, especially if a degree in the science, technology, engineering, or math phase. Again, would be a positive impact for many of our international students, but not something that could happen immediately. It would require congressional approval to have that happen. But again, there's definitely some hope, especially on the high-skilled side. But ultimately, I think it's very unpredictable. We're going to see, I think, certainly some restrictive immigration policies. The question is just whether it will affect immigration across the board or whether it will be targeted more to maybe the humanitarian, temporary asylees, temporary protected status people, or whether we'd see sort of an across-the-board visa ban. Right? Now we'll move on, I think, to sort of the bigger issue that employers, you all as employers, to be prepared for is the worksite compliance. So Nam, I'll turn that over to you.
Great. Yes. One of the things we did see significantly increase under the last Trump administration was worksite compliance issues, and that was targeting both immigration and HR compliance issues more generally for companies. What this looked like was more I-9 audits issued through a notice of inspection issuance. In these instances, Department of Homeland Security, the Homeland Security investigation arrives on site with that notice of inspection to review all of your I-9 files. Companies generally have 3 days in which to respond. So as you can imagine, the larger the company, whether or not you have electronic systems or you're still using paper-based systems, this is a fairly cumbersome process with very small runway. So again, encouraging individuals to review their policies up front, make sure everything is in order, or seek out some assistance in how to streamline your processes or ensure all of your protocols are in place in case that event arises. That also results in more FD&S site visits. That's fraud detection and national security. They have the authority to revoke visas for violating terms of immigration benefits. This often is reviewing H-1B visa holders. They're looking to validate the information that were put in those applications submitted to immigration. Sometimes this is done through email communication, but again, we anticipate likelihood of more site visits. So is that worker where you indicated they would be working from on those applications? And, you know, are they doing the job? Do they have the duties? Is everything in line with what was described in those applications that were approved? And how are you maintaining that record should those questions arise? It also could be more ICE site visits to employers of F1 students on OPT and on STEM OPT. As a reminder, I think a lot of us think of those F1 students as employees because in many cases they're doing very similar jobs. But OPT and STEM OPT is designed to be optional practical training, and there is a training and oversight component that is required as part of those programs and as part of the training proposals that are signed and submitted to those students' universities. And so ICE can visit those work sites to ensure that those students are in fact where, again, they are supposed to be working and have the required oversight as was presented in those training plans. As a result of these various inspections, we saw increased criminal enforcement actions against various consulting firms, particularly those who are contracting or are subcontractors for individuals on H-1B visas. Again, looking to challenge whether or not these individuals are truly contract employees. Where is that employer-employer relationship and how does it align with the applications that were submitted? They also encourage whistleblowing and calling in tips to various tip lines with regards to any kind of immigration violations by private citizens. So we can anticipate that this may come to pass again. We also saw increased criminal and administrative investigations of companies for immigration and wage and labor violations. So in addition to just reviewing documentation, these are instances where immigration actually conducted worksite raids and were looking for criminal law violations, patterns of inappropriate actions by employers in terms of, again, their hiring practices. This is much more extensive than just sort of a paper review of your policies and procedures. We did see an increase in these types of actions as well. And then similarly, we also saw increased investigations by the Department of Justice and Equal Opportunity Commission. And that really not only is looking at your practices in terms of employing immigrants, but your practices in terms of U.S. workers. Is there activities that would discriminate against U.S. workers and give preference to foreign national workers in any part of the hiring process? So a variety of federal agencies are involved and have authority to undertake various worksite compliance. And again, we anticipate these will increase again under the Trump administration.
And Nan, while I move to the next slide, I know it's a question we often get asked. Like you said, we saw an increase in all these inspections during the prior administration, and we expect it again. But just for context, what is the most common reason why a sort of an inspection gets triggered in the first place? I think that for this audience might be helpful to know. Obviously there are certain industries that are suspect, but in your experience, what often is the trigger for this one of these investigations to begin with?
Sure. Honestly, the most common is you have a disgruntled employee who gets mad at you. They got passed over for a promotion. They think it's unfair. They get fired. They think it's unfair. They call and they make a report. And for Homeland Security investigation, that's low-hanging fruit. It's really easy for them to just call and follow up or show up with that audit. They get to check the box and they don't have to do the heavy lifting. So again, consistency in your policies and having those protocols will be a great protection. Specifically, I wanted to just provide some tips with regards to H-1B compliance. Again, as William mentioned, this is the most common type of work visa and sponsorship for a lot of companies who do have foreign national employees, and it is the visa type that has the most significant amount of compliance requirements for employers. So as it pertains to H-1B compliance and tips, as a reminder, and for those who may not be familiar, H-1Bs require a labor condition application. That ties into what William shared about the fact that H-1Bs do require employers to pay a prevailing wage based on the job type, duties, and the physical work location of those employees. That labor condition application is required to be posted at the worksite location for 10 days. Their companies are required to keep that posting notice. They're required to ensure that those LCAs, which describe the job location and title, are in line with where those workers currently are. So again, if those work locations change for those employees, there is the requirement to update your H-1B filings, and to ensure that your H-1B employees are in fact being paid the higher of that prevailing wage or the actual wage. So what the rule says is if a software developer here in Charlotte is required to make at least $85,000 a year, but you pay all your software developers $95,000, then that H-1B employee should be paid $95,000 in line with all the other software developers you have on your staff. The second piece of that compliance are the public access files. Each H-1B worker that you have should have a public access file that is complete and is accessible. Again, if you have an immigration official come to review those files, it must have that labor condition application available for inspection. It should also include a signed copy of that LCA, that posting notice I referenced, proof that the employee also received a copy of it, as well as all of the wage and the benefit information as required. So you should be reviewing those and making sure they're in order for all the applicable employees. And then you should have full employment records, again, in the event of those site visits, who will want to review those H-1B petitions, make sure everything is in a line. They can also request information with regards to other individuals you have on site. So you want to ensure that all of that documentation is easily available and separate from other employee and company information, so that you're not exposing the company with regards to providing information that's outside their purview.
And Nam, a question, I know we saw this a lot post-COVID, we still see it today, for those of you that have H-1B employees who are remote or partially remote, remember compliance is if the employee, is based in Charlotte, but moves home addresses, they're fully remote, that's a compliance issue. I mean, it could be a compliance issue, right, Nam?
Correct. If the worker moves addresses, if they're in the same MSA, so if they move from one side of the city to another, you do still have a compliance issue with reposting that labor certification application. So that's one compliance issue. If they move out of state or they move from one city to another, not only then do you have a compliance issue, but in fact, you would have to seek to submit an entire new immigrant petition. So there's sort of a double layer of compliance issue there.
Yeah. And I think that we saw with COVID and remote work, flexible work, it's come up more and more that you forget that, the H-1B employee requests to relocate, and you prove it, but you forget to update the visa. And so it can, especially when you have these audits, can trigger issues.
Exactly. So these are some recommendations that we have in terms of considering worksite compliance. So again, review what your company has in place. This includes not only your H-1B documentation, but your I-9s for all employees as well. I'm sure, for those of you in the HR world, obviously the I-9 process has undergone significant changes over the last couple of years, especially coming out of COVID. There are options for virtual completion of that documentation if you are a verified company in good standing. But again, ensure that your protocols are in place, you have all the proper documentation for those I-9s, as well as E-Verify. E-Verify requirements are different based on your state. Some states require all businesses to have E-Verify, for example, like South Carolina, North Carolina, there are still some employee number thresholds that are required. So be sure that you understand what those rules and regulations are and you have those all in order. You should have a plan in place for your business in the event of a visit by FDNS, ICE, Homeland Security investigations. You should specifically know which employees are authorized to speak to those agents on behalf of the company, who should be contacted if that person is not present on site, what locations within your building the officers are allowed to enter. Generally, they can only enter public spaces. They are not generally authorized to wander the premises unless they have various search warrants or subpoenas to do so. And then who is tasked with gathering all of the required documentation that may be required to respond to their notice or their request. Consider conducting training on H-1B and immigration compliance within your firm, within your department. Again, what staff is responsible? Is everyone clear on who is to undertake certain activities? What are the various responsibilities for the different visa classifications? Are your talent acquisition individuals trained, as well as all those who are conducting the onboarding, especially if perhaps that's taking places in multiple offices, if you're a company that has multiple locations. If you're not sure, talk with Immigration Counsel for support on how to frame those policies, what to consider, and what is lawful in terms of some of those policies, in terms of the documentation you're collecting, how you're collecting it, how you're asking for it. And then finally, know your rights as a company under the law.
Great. So we've already started to talk a little bit about preparing now, but just again, sort of to get on the compliance side, but to sort of talk more tactical from a company's perspective, especially for those of you that are already used to visa sponsoring in a process. There's sort of immediate tactical which, many of these, with the Trump administration coming in just in a week, are at this point may not be possible, but just sort of, priorities, immediate priorities, and then strategic or sort of bigger picture. We've talked about, for some of our clients, given the risk of increased wages, both for H-1Bs and green cards, getting those wage requests in as soon as possible before any new system goes into effect. I will say if that wage system does go change, it would not be something immediate. It would have to go through regulation, notice, and comment. So again, there's still time if you are, if you're an employer that does sponsor green cards and H-1Bs, considering starting those wage requests sooner rather than later. Upgrading to premium processing, visa people who have visa extensions in place. Anecdotally, we've heard over the last week or so that USCIS has received a record number of premium processing requests. I think people have taken this to heart. They've been worried about what might become. I mean, USCIS, I think, has over doubled the number of usual premium processing cases they've had historically. So I think people are doing this. But again, just keep in mind, I think there's also the fear that the premium processing fee might go away or increase. So again, that's been sort of a push recently. Looking at colleagues from countries that might be impacted by a travel ban. Again, countries, if you look historically, what countries were impacted by President Trump and travel ban, those were countries like nationals from Iraq, Iran, Libya, Sudan. It could be Russia. Now thinking of the political situation, countries where there's not a great political relationship, something to think about if you have people that are from that country, maybe advising them to not travel right now. As Nam talked about, updating your FDNS site visit protocols, preparing colleagues for that. I-9 compliance audits, again, preparing for what that might look like, your procedure, making sure your documentation is in place. Bigger picture, more strategic, to think about, especially as if we see visa bans or restrictions come into place. Thinking about relocations, either starting them ASAP or sort of bigger picture, thinking of alternative options if there is a relocation to the US and the visa is ultimately not approved because of visa bans or new policies, thinking about a plan B, whether they could relocate to another country. Having conversations with business leaders about this, again, if there are sort of plans that you've heard of, about starting a new business or bringing over people for a major project, having conversations now with the business about starting things earlier, being prepared for visa refusals, worst case, and alternative options if not everyone can get a visa in place. Communication plans to employees, if you have, especially you have employees on visas, sponsored visas, having a communication plan so that the employees can learn of updates, timely, but also that they have the information so they don't overreact, that they don't read something more into what it is. So just making sure you have sort of a communication policy in place. Again, looking at relocation, I would always say, considering non-US options in a worst case scenario, that if the visa is refused or not possible, is there another country they can go to temporarily until the visa situation improves? And also, finally, just working with vendor suppliers, especially for I-9, for example, just making sure that they're compliant, they're prepared. If you get an I-9 audit and you have to work with your I-9 vendor, that they're going to be able to get you timely the documentation information you might need to reply to an audit.
One more thing I wanted to add there, William. I think the other piece is just in line with everything we've shared is expect the timelines for everything to be extended. So it's really, I know we always feel challenged when we speak with companies and businesses who come to us and say we have this need, and sometimes obviously things come up and you don't have a long lead time, but if you need somebody here or something needs to be changed from an immigration perspective and you only have a month or 6 weeks, the reality is it's very unlikely that anything will happen in that time. So give yourself plenty of time and plenty of leeway if or you think you're going to have immigration needs or employees who may have to change their status. As much lead and run-up time as you can provide to your immigration counsel, the better. And again, that just gives us the option to strategize if the immediate option is not available.
And then finally, these are tips less for you all in the HR sort of business side, but more for your employees. But if you do have employees that come up to you, for example, that have never needed visa sponsorship, but start, bringing up to questions about their immigration status, what this means, just to sort of give you some tips of what we've been telling individuals. preparing travel plans for 2025 and beyond, either holding back travel or just being prepared to be gone for longer than expected for visa issuance. If someone's on an H-1B and they need to renew it, for that to take longer than historically, so to plan accordingly for additional leave or to work remotely. For those on the discretionary immigration benefits, that is DACA, TPS, et cetera, to renew as soon as you can, just in case the program is eliminated, because generally if the program is eliminated, but you have your work authorization, you don't lose the work authorization you have, you won't be able to renew it. So we have been telling people with sort of those more discretionary immigration benefits, apply as soon as you can. For those that have an option to move to a work-sponsored option, from a TPS EAD, DACA to an H-1B or a work visa, it doesn't happen often, but we've been recommending for those people when you can to consider asking your employer to sponsor you for a work visa for stability's sake. And then again, talking to immigration counsel, for individuals about what options you have, whether it's through family, maybe there's a family-based option you've never explored, or something like that. Because again, just knowing, especially those on those discretionary benefits, the TPS, the DACA people who have never sort of needed sponsorship or had issues may come to a point where they're sort of running up and they're not able to renew their immigration benefits. So just to make sure they've thought about, are there any other options for them either now or in the future? And then similar is knowing their rights. What can they, if they were caught without immigration status or something happened, what are their rights, in the U.S.? What are their rights to fight any immigration case, et cetera?
And then one other thing I just wanted to add in terms of the travel plans and planning ahead. We do know that there have been a number of consulates who have been changing and undergoing technology changes with regards to their visa scheduling process. That has also caused delays in people being able to secure those visa interviews that they need. So if you have employees already here in the US who may also be planning travel and need to go through that visa stamping process, we really encourage them to have those dates for those interviews scheduled before they leave the US. So that creates more stability for them, and also for you as the employers to have a sense of when they'll be able to complete that process and return, rather than getting stuck out and having to wait 3 or 4 weeks for a visa interview slot to become available.
That's a good point. Yeah, and that again, that wasn't even tied to political changes.
Yeah.
It was really a technical issue, but we've seen it, for example, some of the U.S. consulates in Europe. France is notorious. The wait time went from 2 weeks to 8 weeks. And there's really nothing to be done because it's technical issues, is what they're saying.
Exactly. We've had some issues with China as well with a client. So, and again, if you have employees who are stuck out of the country, again, if it's their home company, yes, theoretically they can work for you. But if they're in a third country, right, that creates global immigration issues. They can't necessarily just work for you from Germany or France or another country while they're waiting out for that visa interview to become available. So that's
Great.
the majority of our set discussion. Happy to answer any questions, dig in, address anything we might have missed that you're particularly interested in this afternoon.
Yeah, I guess I'll kick it off. I have a question. One of the things that I generally recommend, it mostly relates to benefits, but we work with a lot of benefit brokers. And one of the things we'll do is we'll provide access to the payroll system, but on a very limited basis so they can just see benefit information. I've always been kind of curious from an I-9 perspective, if you do get called in for an audit, would it make sense to provide that same kind of limited access to see the I-9 information directly in the software for the auditor versus printing out and gathering the information and providing it? I was just curious if you all had an opinion on that.
I think if you have an I-9 system and you can segment it so that is the only information and documentation that they would be able to view, then I think it's appropriate. It may be that the officer is not necessarily going to want to sit there and view it online, so they may ask for that to be printed. But again, you would want to be sure that you had strict firewalls, so if you're giving them access to your system, that's the only information they'd be able to access.
Got it. Thank you.
Yeah, and I think that,
sorry,
we're trying to take on that. And it relates in the sense to paper files too, is I think some I-9 vendors are combined with other HR information systems. And so exactly like if you give them access to part of it, they get all of it. And so we always tell, in the paper file sense that your I-9 files should be separate from your personnel files in a separate drawer, so that if they physically open the drawer, they're allowed to touch anything that they see. And so you need to have your personnel files separate, literally separate. And I think the same goes for electronic too, is that if they have access to all of it, they will look at all of it, and that can create sort of other issues.
Got it. Yeah, and that's why I was particularly curious. Our system is broken up in the same way almost as physical files would be, where the employer portion is stored separately from the employee portion. So thank you. I've always kind of wondered about that. I didn't want to give advice on something, of a nature like that. I guess that leads into my next question. What types of fines could you expect? I do understand it could go up to $28,000 or somewhere around there, but I wasn't sure if you had any additional details about the fines that you're potentially risking by not being in compliance.
Sure. In terms of I-9, each sort of technical error on a form theoretically is subject to a fine, and the lowest fines are, I think, the $300 or $400 range, and as you said, can go up to the thousands of dollars based on how many fines, and again, whether it's sort of a first offense, a second offense, or a third offense. Generally, it's really up to the agencies whether or not they come back with a fine. As a company, you do have the option to negotiate and try to work with the government in terms of any potential final settlement for those fines. But technically, each error on an I-9 form would be subject to an individual fine. So they could rack up fairly quickly, especially if you have numerous employees.
Got it. Thank you. And well, I found this. I don't know that we had any other questions come through so far, but I found this particularly interesting. You always think about immigration, like legal issues related to immigration, particularly with administrative changes related mostly to undocumented workers, not necessarily with, quote unquote, legally, immigrants coming into the country. And I guess just to clarify, based on what you're saying, the H-1B would be a legal immigrant with a specific skill that they're coming into the country, just to clarify for me that I'm understanding that correctly. Like H-1B.
Yes, correct. The
Okay.
H-1B is a specific type of what's considered a non-immigrant visa classification. So it's work authorization based on an individual performing what's considered a specialty occupation, meaning requires at least a bachelor's degree or higher to perform that job duty.
Gotcha. And just, so I have all the questions, right?
No, that's fine. Happy to share.
What would be the value? You mentioned increasing the salary requirements. I think you'd set up to 30 to 40% in some cases. I'm curious, what would be the purpose of the value in doing that or making that change? What's driving that change in the new administration?
Yeah, I think the thought is and I would argue, my opinion is it's a false conclusion, but the conclusion is that H-1B workers are driving down, they're being underpaid for American workers, so that the idea is that the idea is to force the employer to pay them higher, which then that also has some unfairness questions too, but to basically that they're being underpaid, to make sure that they're being paid appropriately. And ultimately, I think it's to make it so costly that not as many H-1Bs are being sponsored. I think that's the goal, is that because to eliminate the visa entirely would require congressional action, but if just by regulation they make it so expensive and impractical, then I think the idea is that President Trump can sort of say, look, I'm protecting American workers because I'm reducing the number of people here on visas. I'm making it so expensive that employers are willing to not sponsor anymore.
Got it. And one other clarification, you mentioned the Dreamer program, I believe is what it was. That's also DACA, right? If I'm correct.
DACA, yep.
Okay, gotcha. If you could just clarify exactly what that is and how it would be impacted again. I know you touched on it, but I was just curious how that would be for that.
Absolutely, yeah. So the DACA program was actually started by President Obama, but what in essence it allowed people who were brought to the US as children, and you had to arrive during a certain time period. So you can't come today and qualify for DACA. But in essence, if you were brought to the US, as a child under the age of, usually around, I think it was 15 or 16, and you'd lived in the US for a certain number of years, graduated from US high school or college, and no criminal issue, you could get a work permit. So a temporary work permit, it's not indefinite, but you could get a work permit, open work permit, that could be renewed every 2 years. The program's now been in existence over 13 years at this point, so that's why the initial numbers of DACA holders were almost 1 million. It's gone down because many of those people have been able to get green cards either through marriage or other means. But in essence, again, from an employer perspective, it's someone that has probably grown up in the U.S., went to school in the U.S., was born in another country, but otherwise, in many ways, maybe culturally American. But again, they weren't born here, so they don't have a U.S. passport. But they've also never needed work sponsorship because they've had this open work permit that's been renewable for the last 13 years, fairly mechanical. And so if the Dreamers program went away because it was an executive action program, which could be canceled, again, Congress does not have to get involved to cancel the program. All of those Dreamers, in effect, would be told, you keep the work permit you have, but you can no longer renew it. And so there could be an employee who comes to you that says, look, I've been working for you legally, there's no I-9 compliance issue, but my work permit expires January of next year and I'm no longer able to renew it. And so in essence, it would mean someone that you might have to end up terminating because they can't meet the I-9 requirements.
Got it. Thank you. Well, this is just incredibly informative. I think it's fascinating, good and bad ways, right? How this would impact not only the businesses, but the employees that the businesses support and look for, so they can do business, right? Really fascinating. And, Dominion, just a little shout out to Dominion, right? We do have an I-9 audit tool. We have HR support, but I think we've seen really clearly during this webinar the importance of consulting attorneys when you have legal questions, right? I don't think, anything can replace that, particularly when things are as complicated as they are right now during this transition period. The hope, I guess, or the goal would be that it becomes more clear over the course of the next year, but, it's hard to say. Well, William, Nam, thank you so much. We really appreciate your time. This is incredibly informative. And again, anybody, they have their contact information here. Please feel free to reach out to them, Dominion Payroll, if you need help. We're all here to help support you as you go through this kind of confusing time. And thank you both again so much. We really appreciate it.
Thank you so much for having us. We enjoyed it. Happy to
thanks all for
assist anyone
attending.
who might need any more.
All right. Thank you all. Everybody have a great day, and please reach out to anybody on the call if you have any questions. Okay. Thank you again.